We're in St. James Park in London, England today, and we're with my friend Mario Lamont Barnes, a law professor from UC Irvine who's an expert on constitutional law. Mario, I've been thinking so much with people's attitudes about gun control. I've been thinking a lot about the work that you did on to stand your ground laws, and just what it was that you learned about guns and the American psyche from that work.
So I guess the thing I would take away is people really do in some ways dissociate gun ownership from the notion of gun violence, which makes little sense to me. But so when people talk about gun ownership, they talk about it as a right, a vested interest, something which shouldn't be disturbed, almost for some group of people as if it's sacrosanct. But then when you think about the related issues of gun violence, they somehow place gun ownership to one side and talk about sort of regulations of behaviors, acting as if you somehow regulate behavior appropriately, then there wouldn't be gun violence, irrespective of the rights we create around gun ownership. And what I would like to tell them is, but if you look about the regulations we do for that behavior, Stand Your Ground was a set of laws that took standard self-defense, which should have been, I could use, a response and sometimes violently when people threaten me with force, and expanded it to allow for us to use much more force in many more situations. So if you marry the notion of ownership leading to a space of, leading to gun violence because the behavioral sort of controls are not there, Stand Your Ground did much more to erase any sort of control. So we have now all of these messages around, I have a huge, and protected right to own and have a weapon, but in the same time, the law has made it much more easy and in some ways lawful for me to use violence, including through and including lethal violence, which could involve guns, in a way that I think is counterproductive.
Well, it's so ironic to think that there's something that the law does that actually promotes violence instead of inhibits it or limits it.
Yeah, Stand Your Ground was, at bottom, critics, and I agree with them, was about expanding your opportunity to respond with violent force to a set of circumstances much broader than historically had been available to you. If you partner that with greater availability of guns and people having a mindset, I have a right to have my gun, then any notion of being confronted with something that you think is a dangerous situation produces an opportunity, right, for people then who are carrying, concealed or not, to say, I felt threatened and needed to use guns. And as when we talked about this before, what I told you about was the way in which there were racialized and socialized aspects to this in terms of both who the victims are and then who's able to allege successfully a Stand Your Ground defense. And so, but those are aside to the question you just had.
But for me, they're central. It makes people of color less safe in America.
Oh, absolutely, especially when you think that of the large number of stereotypes around black and brown men where they are perceived as more threatening, right? So the very fact of me living in my skin and walking down the street means that someone uses violence and says, well, I was afraid of him because of who he was and how he looked, whether I was presenting, in my own mind as particularly menacing or dangerous, comes into play, which is, again, the statistics suggest that people are much more inclined to view certain types of people as potentially violent, and then if you give them the opportunity to use force earlier than would historically be available, it's a problem. I just taught a course on international humanitarian law and law of armed conflict, and one of the things we talk about is anticipatory self-defense, right? This notion of being able to use violence in anticipation of being subject to, and to me that's what Stand Your Ground promoted, right? This notion of, oh, I view you as threatening, so before you've actually even done anything that looks historically like, presenting a situation where you're threatening violence against me, I can take action. And again, we've broadened the circumstance under which the law is willing and able to facilitate or accommodate ever broadening uses or ever increasing uses of violence.
I think probably a lot of people are asking you questions about the recent Supreme Court abortion.
Yeah.
So what are you telling family and friends, like non-legal experts or students? What's going on? It's very puzzling for somebody who's just an ordinary person.
I have a harder time with, there's always been a world in which the Supreme Court has had opportunity and on occasion reversed itself on certain types of opinions, and some of that has been good, right? We think that the Brown versus Board of Education reversal of Plessy versus Ferguson is an improvement, but I don't know that we've ever had this type of reversal in two ways. On an issue that was so politically freighted, in an evenly divided way in terms of the social context. And I don't know that we've ever had a reversal in the context of substantive due process where what we have said is something that we have deemed to be a liberty-protected interest now being treated as if it no longer is, right? Which is to say, the Roe decision and Casey after it, which sort of updated Roe, were about an understanding of that right to choose belonging to an area of privacy where the court, based on what we call a penumbric view, looking across the Constitution, sees that even though there's no explicit sort of endorsement, that if you look across what is held important in the Constitution, that type of privacy is something that's found in numerous places where the court, in a case called Griswold, which was a contraception case, said that should be respected, and that before the government should encroach, it should have a really, really important reason, and it should do so in a very limited fashion. And so we have never had them sort of revisit and decide that something that belonged to the protected group of liberty interests, like the right to marry, like the right to vote, like these privacy rights, were on further reflection not protected. And so I think that holds huge consequences for the right to choose, and deeply upsets public health and women's safety. But it also now threatens in a larger way what we might think about as substantive due process and liberty rights, right? Which is why many people were very upset with the Clarence Thomas concurrence, because he seemed to suggest we could then go back and relook at other cases rooted in privacy, like Griswold, which is contraception, like Lawrence versus Texas, which sort of embraced a protection of intimacy to include between gay partners, right? So like those things could be revisited. And then he even said the marriage cases, right? And marriage doesn't belong to that group of privacy protected interests. Marriage is its own separate protected liberty interests, like the right to vote, like the right to make medical decisions for yourself. So he seemed to be opening the door to the court going back and revisiting these things. And I'll come back to my first point. This is more problematic given now that I think people are much more understanding of the political sort of element or nature to the court's decision, right? Which is that we used to think, well, conservative justice is as bound by a liberal one, by the text and by certain things. But it seems what we've learned from the Dobbs decision is that the current court is willing to act on its conservatism in a way that upsets sort of previous areas that we might have thought would not be disturbed, right? Which is, so everything is on the table for reconsideration, not just things that have been traditionally sort of problematic, like affirmative action or gun rights, but now we're in a world, this new world of 14th Amendment reimagining what liberty protections we have. That makes me very nervous, right? I often have written about equal protection as being the problematic area of the 14th Amendment because what is equality can be very different. But we thought we were on solid ground with the understanding of how substantive due process works. Once something is declared to be a protected liberty interest, what follows it is a pretty high standard for the government before it can intrude upon it. Now that that's opened up for reconsideration, it's going to be an interesting and perhaps difficult time to be a constitutional scholar or to be someone who cares about or thinks about rights as something that are somehow stable.
Yeah, and that's something that the church is deeply connected with, deeply concerned about. And I just worry so much about friends of mine who are gay people who are married. I worry about all these other possibilities that we may be in just a very retrograde, backward moving moment in our.
I agree. I worry about women of color and poor women, right? And now that geography will control choices. I mean, I was reading a case in the paper today about a 10-year-old who has a pregnancy as a result of a sexual assault in Ohio, and the state suggesting that under the recent change to the law precipitated by the Supreme Court opinion that child and their family could be forced to now bring that child to term. And I feel like that type of dismissive and in some ways insensitive treatment of a very personal and problem and trouble for which normally the family would have a broader set of choices that law would respect, is what you're going to see much more often, right? Which is people having many fewer choices, but the people it mattering to are being poor people, women of color, other who have historically not had access to greater resources to give themselves different choices, right? You're essentially going to have to be able to travel to a place where the law is more forgiving.
It just seems very unfair. But I'm so glad that you took the time with us today. These things happen. I often think, what would Mario say about this?
Oh, I often say it in my class. And this past semester when I taught constitutional law to first-year students, I taught the set of cases of Roe and Casey and leading up to the Dobbs, the Mississippi, and the Texas cases. And I said, more than ever, I am concerned that with a supermajority of conservatives on the court, that we might get some real different in the approach to this, what has been protected liberty interests. And my students pushed back against me and said, but the court would have to abandon so much history and tradition and respect for stare decisis. And I'm like, and so we'll see what those things really mean in a matter of weeks. And as soon as the opinion was leaked, which is rare within Supreme Court history, my students who are now done with the class start writing me and saying, Professor, wow, this is, and I said that the only thing that gives me hope is that, your generation will have both the incentive and the skills to respond and to create more just and equitable laws, because in the end, the court is not the final arbiter. It is the people, right? So we the people. And so if this is something that does not sit well with the majority of a democratic society, we should bring a means to bear to have a different result. I mean, ultimately, we have in the past really leaned on the court to sort of heavily weigh in areas where we might not have been ready as a society to move forward with, but now we might have to rely on ourselves.
I would have loved to have been one of your students during this last 6 months.
I don't know.
I think I would have learned so much.
but I would have loved to have you with my class. I am sure you would have been paying attention.
I would have been one of those guys in the back row watching their...
I know. Years ago, Malcolm came to a class when I was teaching at a university in Florida, and he's like, there were people who are using their computers other than for... I was like, oh no. I'm so shocked. I really wasn't. But my sense is at this time it's more important than ever that the students are engaged, because I think, if nothing else, this opinion shows us that there are real issues that matter in people's lives that are up for consideration and reconsideration. And the fact that outcomes in the past have been consistent with our values and beliefs about the way in which law should operate in our life does not guarantee that they will continue to be so.
Well, thanks so much for being on our show. My name is Malcolm Clemens Young. I'm the Dean of Grace Cathedral in San Francisco, California. I'm with Mario Lamont Barnes, law professor at UC Irvine. Thanks for watching More Good News.